Good morning. My name is Dave Waxse, and I'm going to try and lead us through this discussion this morning. First thing I want to explain is the reason I got involved in the forensic science issue is a couple years ago I was head of the judicial division of the ABA, and when you're head of that you get to pick a program, and I had just recently read the National Academy of Science report on forensic science and saw there was a big problem there that maybe the ABA ought to be working on. So that's my explanation of why the ABA is on my slides. I just change the heading each time I start over. The topic is way too broad for a 50-minute presentation. So we're going to just touch on a lot of these issues, and the in-depth discussion will have to occur afterwards. But to put this in a big perspective, the question I have is, what is the role of the court in this whole discussion? And as the slide indicates, I think it's the same thing that's in every civil or criminal litigation. We want to have a system that'll work and promote public trust and confidence. So we're going to today focus on the science part of that. And our presenters are Judge Gertner and Amelia Maxfield, and I'll let both of them tell you a little more about themselves.
Good morning. My name is Amelia Maxfield. I am currently a public defender in the state of Maryland, formerly post-conviction counsel at the National Association of Criminal Defense Lawyers. I am very honored to be on this panel with these esteemed judges. My contribution is working on the microscopic hair comparison review, which I will be talking about momentarily.
My name is Nancy Gertner. I was a federal judge for 17 years, and now I teach at Harvard Law School, do a little practice on the side, write, and mainly, as my husband said, now that I can speak, I can't shut up. But I got involved in this. I'd been a criminal defense lawyer and a civil rights lawyer before I was a judge, and I was appalled at the way forensic evidence was treated by, frankly, both the lawyers in front of me and also by the bench. And so I began to do things in my court that we'll talk about.
Thank you. And as I've already said, I'm a judge, and I got involved with this through the ABA. How many of you have actually read the National Academy of Science 2009 report? Anybody? Well, that's part of our problem. There are vast numbers of judges and lawyers that have not only haven't read it, they aren't aware that it exists. This committee was formed in response to a request from Congress to look at this issue. And for those of you who haven't run into the NAS, it's a private, nonprofit, really reputable group that looks at these kind of questions. And what they did here is they created a committee to conduct the study. Judge Edwards of the D.C. Circuit chaired it along with Constantine Gatsanis. Is that how you pronounce it? You guys don't know either. 2009 is when the report came out. There's where you can get your free copy. It's downloadable for free. And so what did the committee determine? I think you'll agree with this after you hear the rest of this presentation. It's really amazing that we're still proceeding somewhat similar to the way we were before the report. But the conclusion is, with the exception of DNA, no forensic method currently used in the criminal justice system has really been shown to meet the applicable standards. So, why did they reach that conclusion? First, it's just amazing when you start looking at these individual areas how there is almost no scientific evidence to try and support the conclusions they're reaching. And let me quickly tell you a story about how I got interested in this area. Magistrate judges do something called identity hearings, which occur when someone is arrested in our district based on a warrant from another district. And the rule says that if you dispute you're the person named in that warrant, you have a right to a hearing. In this case, the guy was living in Kansas, been here for 30-some years, had a green card that was in good standing, had a house, a job, and appeared to have no criminal record. But a fingerprint was taken when he renewed his green card, which you have to do every 10 years. And the computer system said there was a warrant for his arrest out of the District of Texas. And he said, that's not me, I didn't do that. What the warrant charged him with was failure to appear at a trial in 1972. This is like 2014 or 15 when I get the case. The attorneys in the case had really no concept of scientific evidence issues, but I had read the report, so I had some idea, and the only evidence tying this guy to the Texas warrant was the fingerprints. So we're going to have a hearing to see if that's sufficient evidence. The FBI's fingerprint person wasn't available, so they brought in the local county fingerprint examiner. Neither attorney really challenged her statement that I've reviewed these prints and they're a match. I, having read this report and knowing the Daubert issues, thought before I'm going to send this guy someplace he says he doesn't belong, I'm going to ask her the basic questions. So I started with her educational background. I said, where did you get this expertise in fingerprint examining? She said, from a correspondence course. I said, well, who provided the correspondence course? And she said, the International Association of Fingerprint Examiners. And I said, well, I'm not familiar with that group. Is that a governmental group? No, that's all we fingerprint examiners set this up and we belong to it. It's a membership organization. I said, well, how do they certify you? She said, well, we take a test. And I said, well, do you have any knowledge of whether this test has ever been validated? No, I don't know anything about that. I said, well, tell me how it is you go about fingerprint examination. She said, well, I just look at them. I look at one and look at the other and tell you whether it's a match. I said, well, is there any science involved in this? She said, no, it's just observation. And I said, well, I thought there used to be something about the number of points you had to match before you could say it was a match. She said, well, we used to do that, but we voted to stop doing that. And I said, well, you know, I have an obligation to make sure this is the guy, and so I don't think I have enough information to make that determination. So I'm going to recess the hearing, and the court has the right to get its own expert. And I had already determined to release the guy in bond because he had all the criteria for release. He had no record, had everything you need. So I'm talking to Professor Mnookin, who's the fingerprint person on the committee that wrote this report, and she said she would be glad to come to court and provide what they knew about fingerprint examination in terms of whether it's admissible science. In the meantime, while I'm trying to work that out, unbeknownst to me, they had appealed my release order, and the guy had been kept in custody when the judge in Texas said, no, just keep him locked up till he gets down here. So the public defender came in and said, Judge, we've changed our mind since you, and I'd raised this with him at the start. I said, I can't find any law on who has the burden and what is the standard here. And they couldn't find any law either. And they said, since we can't get that cleared up, we're just going to waive this, go back to Texas, and we know there they've got to prove beyond a reasonable doubt he's this guy. Well, I'd looked on electronic case filing to look at this Texas file. This guy's not even named in the Texas file that he supposedly failed to appear at. They had some John Does, but they'd never made a determination of who the John Does were. Somebody had just decided this was one of them and issued a warrant for his arrest based on the fingerprints. So when they got back to Texas, the prosecutor, when confronted with all this, just dismissed the charges. But, you know, if I hadn't raised the issue about the science, I don't know where the guy would be now, but right now he's back in Topeka, still doing his construction job. That's a long story about how it got me interested in how much of this was going on. And when you read the report, you'll see the science is missing. And there's also the problem of who's doing this so-called science. There's no real provision for certifying people doing this kind of stuff. And there's no accreditation program that's set up to really make sure these labs are working right. And there's nothing to make sure they're doing it the way they say they're supposed to be doing it. So when you put all those things together, you have the conclusion that I already read you, that there just isn't a basis to rely on most of this so-called science. So the question is, what do we do about this? And there's a really simplistic answer, and that is Daubert applies in criminal cases. And most of these so-called sciences would not meet the Daubert standards. And this question of how bad is it, there are a lot of groups working on the problems of wrongful convictions. And one of them is the Innocence Project, and I don't have their current number. It's up to over 350 cases they've exonerated people using DNA, which the report says is reliable. And one of the people that's been involved with the Innocence Project has written a book called Convicting the Innocent, where he analyzed these exonerations with the question of, well, if they weren't guilty, how'd they get convicted? And this is the conclusion from his study. The largest source of wrongful convictions is eyewitness errors, and that ties back into the science because there's plenty of research showing that humans are terrible at identifying other humans. They're also terrible about remembering what they saw earlier. And when you get to cross-racial identifications, they're almost incapable of doing that. And yet 75 or 71% of these people in that group, that's the basis. But the second largest is just bad science. And we'll go through some of these. Here's some of them that clearly are present in these bad science cases. And I don't have time to give you a great detail on arson, but you need to read about the Willingham case, which is a guy in Texas that was executed for a crime that the Innocence Project says he did not commit. And it's a very good story. PBS did a program on it, and the New Yorker did a big article on it. So when you look at these issues under arson, you discover that most of them don't mean anything that the experts claim they mean. When you look at bite marks, you have similar problems. I mean, they have people out there called forensic orthodontists who will testify in court with absolute certainty this is a match, and yet when you try and get to the same questions in Daubert, is there any scientific basis for that? It's pure observational, there's no. And hair comparison is one of the problem areas. So what I'm going to do at this point is stop and let Amelia talk to you a little bit.
All right, good morning. My name is Amelia Maxfield. So I'm going to talk a little bit about microscopic hair comparison, and particularly the FBI's microscopic hair comparison review. This is an effort that started in 2012 that I was able to work on for a couple of years and is somewhat ongoing, and that's emblematic of the problems with forensic science identified in the NAS report and that Judge Waxse spoke to you about. Before I start, I think it's important to just really highlight something Judge Waxse talked about, which is the way that forensic science was introduced into our criminal justice system. As you can see, fingerprint comparison came over to the US from England during the World's Fair in 1904. The first time it was admitted at in a court of law was in 1911 when Thomas Jennings was convicted of murder in Illinois based on a fingerprint. And from there, forensic technologies just continue to be developed and continue to be admitted into court without rigorous admissibility standards. In 1960s, the FBI developed microscopic hair comparison, and I think it's important to think about that this science, pseudoscience, was not developed in a lab. It was not developed by scientists. It was developed by law enforcement officers in the FBI lab, who on their own decided that hair was unique and that they, if properly trained, could identify someone based on their hair. They decided that internally, started doing it, and spread this science throughout the country. They did it for over 40 years before using DNA testing to validate what they were finding. They trained thousands and thousands of state and local hair examiners for over 30 years in this science without ever stopping to think about whether there was any validity to what they were actually doing. Arson investigation, something mentioned by Judge Waxse, is a basic pseudoscience. Other things that are more common, comparative bullet lead analysis. This was developed after the JFK assassination by the FBI, and in the early 2000s, the FBI reviewed all of their comparative bullet lead analysis work because they found that there was no scientific basis for what they were doing, trying to match the composite of a bullet to a specific gun or box of bullets somewhere else. Excuse me, in the 1980s, DNA was developed and used for the first time in a criminal case in 1987, and DNA is different. DNA is the gold standard of forensic science, and when I say DNA, I mean nuclear DNA. So one person's DNA from blood or semen left on a crime scene that is uncontaminated. We're not talking about DNA mixtures. That's a whole other can of worms that still has some validation work to be done as well. We're talking about simple nuclear DNA. And DNA was different from these other forensic sciences because it was actual science. We know how frequent certain alleles are across populations because scientists have done the studies to validate that. We can put an actual statistic on how rare a match between someone's DNA and that person is. So there's actual science underlying DNA, which is what separates it from the rest of these forensic sciences. So the result of all of this is where we end up today with what's been referred to as the CSI effect, which is that it's almost impossible to get a conviction anymore with a jury without providing some sort of forensic evidence. Juries expect it, they look for it, and prosecutors have a hard time meeting their burden unless they can provide some sort of forensic science, regardless of how scientific or valid it actually is. And with the rise in DNA and the rise in innocence work and wrongful conviction work, we could see the real problem caused by misapplied or flawed forensic sciences. As you can see, 46% of the wrongful convictions that have been overturned by the Innocence Project were the result of the misapplication of forensic science. That can be from invalid disciplines, just completely made up science, insufficient validation, so doing something and applying a statistic to it that validates it without actually doing the statistical analysis to know that there's some validity to what you're doing. That could be misleading testimony, which is part of what we reviewed in the microscopic hair comparison review. So seeming more sure about a match than you actually are. It can be mistakes, simple lab errors, lack of oversight, lack of procedures in the lab to keep contamination out, and it can be misconduct. In Massachusetts, I don't know if Judge Gertner will talk about this, but there's an ongoing lab scandal based on one analyst who was just completely making up her findings and contaminated thousands and thousands of criminal cases. And so I'm going to talk about microscopic hair comparison because it's a great example of one response to this problem. So 1/4, about 70 of the first 300 people who were exonerated using DNA testing, so proven to be completely innocent of the crime that they were convicted of, there was microscopic hair comparison testimony in their trial. So just the NAS report has been covered, but I will just note that it actually singled out a few disciplines as particularly inaccurate. So if you ever hear about these disciplines being used, if you think back on your casework and you remember them being used, you might want to think about looking back at that issue. Tire-tread impression, bite mark analysis, hair and fiber comparison, and arson investigation have not been subjected to sufficient scientific evaluation to be admitted in a court of law. And the NAS had some scathing things to say about hair comparison in particular. The last quote is my favorite: "The committee found no scientific support for the use of hair comparison for individualization in the absence of nuclear DNA." So there's really no scientific support for being able to find a hair at a crime scene, take a hair from a suspect, look at them under a microscope, and declare that that hair comes from that person. The NAS found no scientific support for that, and that's what the FBI did for 30 years. Okay, so what is microscopic hair comparison? This is a overly simplistic view of what two hairs look like under a microscope. But like I said, it's basically the ability to find a hair at a crime scene, take a hair from a suspect, look at them under a microscope, point out points of comparison, and decide whether they look alike, they don't look alike, whether there's a match, they're consistent with each other, whether you can exclude them, you can say that that hair did not come from that person, or whether it's inconclusive. And hair comparison rests on two hypotheses, both of which are still unproven to this day. One, that a properly trained hair analyst can make that visual comparison between an unknown hair and a known hair, that we're capable of looking at those two things using our mind and our brains, not being contaminated by cognitive bias or anything else, and objectively deciding that they are the same or are different. And that two, that a properly trained examiner can provide a scientifically valid estimate of the rareness of that association. So even assuming that one can do that, what does that mean? We don't know, because no one has done the statistical work to show us how rare it is that a hair looks alike or looks different. We just don't know. So the FBI microscopic hair comparison review started in 2012, and it came about sort of as a result of the NAS report, but then also the result of the exoneration of 3 DC men, all of whom were convicted based on the testimony of FBI hair analysts. And as you can see, they each spent significant amount of time in prison. Donald Gates spent 28 years in prison, Kirk Odom spent 31 years in prison, and Sante Tribble spent 28 years in prison. And actually, when the hair in Sante Tribble's case was tested, it turned out to have come from a dog, even though the hair analyst testified that it came from Mr. Tribble. So not only were they innocent and proven innocent, the testimony in their cases was pivotal to the conviction. So in 2012, the Justice Department and the FBI decided to go back and review the criminal cases in which their hair analysts had testified. This was really a sort of unprecedented move for a lab and a prosecutorial agency to admit that they had made mistakes and to take the burden on of going back and trying to correct those mistakes. So the review started in 2012. It was a collaboration between the FBI and the Department of Justice, the Innocence Project, the National Association of Criminal Defense Lawyers, and a pro bono law firm, Winston & Strawn. So we developed some criteria for the review, for getting cases into the review. So there had to be a criminal conviction. It could be a plea or it could be following trial. There had to be hair analysis done by the FBI and actually used at trial. Used for the conviction, either in testimony or in lab reports. And there had to be a positive hair association. We didn't consider when the FBI looked at a hair and excluded it as not coming from the defendant. And it also had to be before 2000. 2000 it was a rough cutoff, but it was basically when DNA testing of hair became the lab standard in the FBI. So there should be some validated confirmation that the comparison is actually correct. So the FBI went back and looked through all their case records and did an exhaustive search and initially identified 21,000 cases where hair analysis played a role across the country, federal cases, state cases, in both systems. That was eventually narrowed down to about 3,000 cases where there was a positive association. And as of September, the review is about through 2,500 cases, so nearly through the identified cases. And these cases were there's no record keeping at the FBI throughout most of this period. These cases were identified by travel receipts from analysts, by notes found in old files across the country. It was really quite an effort, even just to figure out where these cases were, and then to try to find the transcripts and the lab reports. So the way that the review works is the FBI identifies the cases. They do a preliminary review under these 3 error types that we developed that I will get into. The National Association of Criminal Defense Lawyers does the secondary review, and then we send out our results to the attorney or the defendant, the affected defendant. So the three error types, and I should note that our review was really looking at testimonial error. We weren't considering whether the hair actually belonged to the defendant, but whether the analysts said things in testimony or in the lab report that are not supported by the science. So we had three error types. Error one, the examiner stated or implied that the evidentiary hair could be associated with a specific individual to the exclusion of all others. That's something like, my opinion is that those hairs came from the victim. Error type 2, the examiner assigned to the association a statistical weight or probability or provided a likelihood that the questioned hair originated from a particular source that could lead the jury to believe that a valid statistical weight, not 8, can be assigned to a microscopic hair association. So that's something like, I would say the chances of it being from anybody other than the defendant would be highly unlikely at best. Highly unlikely is a statistical probability. It would, to me, mean more than 50%, although, every person would have their own interpretation of what that would mean. There's no science underlying that. We don't know how likely it is that it could come from anyone else. And the third error type is the examiner cites the number of cases worked in the lab, the number of samples from different individuals that could not be distinguished as a predictive value in order to bolster their conclusion that the hair belongs to a specific individual. So this is something like, I've been a hair examiner for over 20 years, and in that time I've done literally thousands of hair comparisons. And only on 3 occasions in those 20 years have I ever had 2 hairs that I could not differentiate. You have no idea how often they said this. So what this communicates to the jury is that I'm making this comparison, and not only that, in my experience, I can always determine when hairs don't belong to someone. I can always tell a match or not. And they didn't keep records. We have no idea whether they actually did 10,000 hair analyses, how often they could exclude, they could identify, how often it was inconclusive. They kept no records. And I should mention one of the most prolific FBI analysts, who also is just a sort of bad actor within the FBI, Michael Malone. He gave this exact testimony over 20 years, his whole career, and the numbers never changed. They never increased. So it's clear from what they were saying that there was no basis for this. It was just bolstering their conclusion for the jury. So what did we find? What we found was that over 95% of the testimony reviewed contained erroneous statements made by the FBI. So we went looking for these errors, and we weren't sure what we were going to find, but the result was overwhelming. They were saying this all the time. Most of those were made in trial testimony. About 95% of the last time data was collected, the 327 trials, 95% of those reviews had error. And out of 952 pleas, 52% of those had error as well. So that's a lab report that ostensibly could have been the basis of a decision to plead guilty, and there was erroneous statements made by examiners in those lab reports. And this affected tons of cases. So overall, there were originally 77 death penalty cases in the review. We weeded those down based on the factors I listed before, and ended up reviewing 41 death penalty cases. 36 of those had erroneous testimony in them. And there were 18 defendants who were already executed. 12 of those had error. So it's really too late to go back and fix those mistakes. And there's currently people still on death row litigating this who were convicted based on this testimony. Actually, the U.S. Supreme Court recently denied a writ for a hair defendant out of Florida who had erroneous testimony in his case. So the other thing we found was that this was not 1 or 2 bad actors within the lab. This was everyone. 26 out of the 27 lab analysts who testified in court made erroneous statements. Interestingly, only 1 didn't. He only testified once that we know of. It was the Joseph Sledge case, and he said everything perfectly within the bounds of supportable science. But they went back and DNA tested the hair in Joseph Sledge's case, and it wasn't his. He didn't do it. He was exonerated after 40 years in prison. So even when they said, like I mentioned before, this was a testimonial review. It was about what they said, not what they did. So we still don't know whether those analyses were valid, but I mean, this statistic is powerful to me that this was a widespread problem. So when this went public in April 2015, it was a huge deal. This is just a picture of the front page of the Washington Post. The FBI and the DOJ, they admitted this problem. They got out in front of it initially and stuck by the review, and that was really great. So what does this mean for the federal bar? Two things. First, the Department of Justice has agreed to waive procedural defenses in these cases. So obviously these are very old cases, and they've agreed to not rely on the statute of limitations in order to actually resolve these claims. They also admitted in a letter to the Senate Judiciary Committee from last fall that the errors constitute false testimony and that knowledge of the falsity should be imputed onto the prosecution. That's really huge for a prosecutorial agency to admit, first of all, we're gonna let you resolve this. We're not gonna rely on procedural defenses. We wanna get to the truth of this. And then second of all, that we will admit that this was testimony, this was false testimony, and you can impute that knowledge on the prosecution. That's a huge burden, huge burden in relitigating these cases. The FBI will also provide DNA testing in any of these cases. We are happy to arrange that for any attorneys interested in relitigating any of these cases. And also courts have been dealing with this issue around the country. So there's been some success and some failure. And I think something we'll talk about is how difficult it is for lawyers and judges to take these new scientific findings and apply them in a court. And that's something we're really focused on. But there have been two successes. First, George Peratt, he spent 30 years in prison based on one hair found on a bed sheet in a rape victim's home. His conviction was recently overturned in Massachusetts last January. The decision said that the FBI hair analysis testimony exceeded the limits of science and never should have been admitted. And more importantly, it said that if this case were litigated today, this testimony would not be admitted. It would not meet our admissibility standards. So that's great precedent. That's huge for these cases moving forward. Also recently, this fall in Arkansas, the Arkansas Supreme Court granted 2 requests for writ of error coram nobis. They expanded the writ to include flawed forensic science cases like microscopic hair comparison cases, recognizing the need to go back and fix some of these errors. And then there have been several exonerations on microscopic hair comparison cases. The other thing that's happened is there have been state and local hair reviews. They've popped up in about 12 jurisdictions because, as I mentioned, the FBI not only gave this testimony, they trained state and local analysts, and so there are more cases out there like this based on the analysis of local hair examiners. All right, and I can save this. I think it's some of what you'll get into, but there's been a broader ripple effect of the results of the review. Other government organizations and I don't know how to play from there.
Okay.
Beginning to look at other disciplines and the status of the science in other areas.
Well, this doesn't get me back, Amelia.
I think.
Okay. I've already told you my personal experience with the fingerprint issue, but fingerprints are one of the huge areas that have been used for convictions that now have questions. How many of you have heard of the Brandon Mayfield case? It was pretty extensively covered back when it happened. This was a lawyer in Oregon who got charged in the Madrid train bombing based on a fingerprint they found on a fragment of the bomb. So Spain asked for his extradition. The FBI arrested him and held him. Finally, his lawyers convinced Spain to redo the evaluation, and the second evaluation determined it wasn't his fingerprint. The FBI, for a while, apparently was not willing to rely on the Spanish reevaluation, so they held him even longer. He ultimately got out, I think, in like 8 or 9 months of incarceration, and he ended up getting a multi-million-dollar settlement from the federal government. But one of the things that happened after the Mayfield case, a professor in England decided to use that as a way to try and get some science behind whether fingerprint examinations work. So what he did is he went and found, I think, 9 cases in England where fingerprint evaluation had been used to convict people. And he told those 9 people he was doing a scientific study of how fingerprint examination worked, and he wanted them to review the Mayfield prints to see if they agreed they were not a match. That's what he told them. What he did was got the prints from the cases they'd already testified under oath were matches and had resulted in convictions and incarceration, and gave them those under the pretense they were the Mayfield ones. So when you look at the results of these, everybody had positively identified their set of prints. When he goes through the review, all these people who had previously testified under oath they were matches now say it's not a match. One guy said it was identified, and one identified it as, and the conclusion was, you know, the vast majority of these people were willing to lie under oath about matches until they were given prints that they were told didn't match, but it was the same prints they'd testified under oath did match. And so when you start looking at the scientific basis.
Sometimes it wasn't a question of lying. Sometimes it's a question of the observer bias. In other words, if you're told that the defendant's print is in the, is in the sample, then you're going to find positive. If you're told that the defendant's print is not in the sample, then you may have more undecided. So that in a purely subjective science, which is what really fingerprint is, purely subjective. It's mapping one print on another. It's my judgment that these map on one another. The observer bias is critical. And that's really what Dror was talking about, because it was the fact that they had been told that this was the Brandon Mayfield misidentification. Yeah?
Yeah, I actually told that's called double-blind testing.
That's right.
Are you aware of any court that's ever thrown out any of these samples based on failure to do double-blind testing?
You want to get to that? I can.
Yeah, go ahead with that.
I deal with the failure of the court. That's my part of this.
All right.
Yeah, no. Should I talk now, or do you want to?
Let me get through to that side. The report has a lot of further explanations for why this occurs. And I don't think we have time to get into each of these in detail, but now we're back to Professor Gertner, because she was the only judge in the country in response to the report that took action. So why don't you explain?
Okay. I can just go there.
You can just use the clicker.
Is the report on the clicker?
No, I mean there's slides that talk about your.
Oh, okay. It was partly the NAS report. I was supposed to give a presentation about the NAS report and its significance to judges. And the day that I left for the conference, I was told by my clerk that I had just been affirmed in a case for not giving a hearing when there was a fingerprint challenge. I didn't know what case they were talking about. It's not unusual to wind up having a Court of Appeals decision that bore no relationship to the decision below. But I took a look at this, and here's what happened. There was a felon in possession of a firearm charge. There was a fingerprint on a gun, and they linked it to the defendant. The lawyer had done no pretrial preparation at all, so far as I could figure out, nothing in front of me. But on the eve of trial, he sends a motion to the court seeking to challenge the fingerprint. There was absolutely no basis for the motion, but I knew the science, and I knew the challenges to it. I added that to the pot. And I said, I'll give you a hearing. Monday morning, after we select the jury, I send the jury home, and I said, okay, the government says I have my witnesses here, and the defendant comes to me and he says, Judge, I have nothing. I said, say what? He says, I have no witnesses. I did this just for the record. I said, what do you mean you did this for the record? You're in front of me. You don't do this for the record in front of me. And he says, Judge, you give me too much credit. And indeed, that was true. At that point, I listed for him what he could have challenged. I noted for him what he could have challenged. Candidly, I was making a record for an ineffective assistance of counsel challenge ultimately. But I couldn't hold a hearing with myself. The government's witnesses were there. I was not prepared. There was a conviction. The case goes up on appeal. And the court at the First Circuit affirms me for not holding a hearing when I was willing to hold a hearing, and makes findings about the reason why I didn't hold a hearing in terms of the validity of fingerprint evidence. It was essentially, I was so furious at that, I called up the people at the conference I was supposed to go to, and I said, do you want to disinvite me? It appears there's a decision now affirming me for not holding hearing. And instead, it turned into a different kind of presentation, which was a presentation of why the science has not made it to the court. And part of the reason for that is that old science, which is to say not DNA, but ballistics and fingerprint and hair microscopy, as it's called, which had been introduced before the DNA revolution, it's almost as if precedent forces judges or encourages them not to challenge it. And that was the gist of the First Circuit decision, which is that I had a right not to challenge well-established evidence, even though it had no scientific foundation. And when a judge doesn't expose the science to any meaningful review, the judge is likely to be affirmed. And the presentation I gave is, I think that the core here is not not lawyers even, not district court judges, but that courts of appeals will affirm just about whatever a judge does in this area on an abuse of discretion rationale. In other words, if I excluded ballistics evidence in my court, but the judge next to me on a similar record includes it, allows it to be admitted, we'll both be affirmed because it's within the range of discretion. And the problem was that abuse of discretion, literally one standard was whether a conscientious judge acting in good faith made this decision. So essentially, in order to be reversed, I have to be in a coma and a thief. There was when you think about it. And so I wanted to do something proactive after this. And what I did, I said, I made an order. I issued an order, and I said that the NAS report essentially created the foundation for a hearing. You don't have to show me. The NAS report, and now the President's Committee on Scientific and Technology Advisors report, called PCAST, which came out this past year, provide the basis for the challenge. And if you have any of the science that is identified in those reports, I'm going to give you a hearing. I'm not going to say I'm going to exclude it or include it, but I'm certainly going to give you a hearing. Frankly, it was a way of making sure that lawyers prepared. The question was whether the extent to which a particular forensic discipline is founded on reliable scientific methodology that gives it the capacity to accurately analyze evidence and report findings, and the extent to which the practitioner in a particular discipline could make a judgment free of bias. Let me sort of translate that. There are two issues here. One is an issue of the field, the validity of the field and its techniques. And as Judge Waxse was just suggesting, there are fields like hair microscopy and like bite marks, which are junk science. And that as to which, if a judge, the introduction of it should be an abuse of discretion. As one of the scientists that I worked with said, if you wanted to introduce dunking in court, which occurred during the Salem witch trials, right? If you had dunked in water and you died, you were probably lying. If you were dunked in water and you survived, you were telling the truth. If someone wanted to introduce dunking, we would say that's beyond the pale. That is not within the range of discretion. Well, there are certain fields now that are not within the range of discretion at all. And then that's one part, which is does the field have foundational validity? Can it speak to the issues that it says it can speak to? And then the other is validity as applied. Does this practitioner have the skills to make the decisions that the field purports to make? What are his error rates? So one is focusing on the science, and the other is focusing on the practitioner. The report noted that fundamental questions haven't satisfactorily been dealt with. In the past, this was usually presumed, this kind of evidence was presumed to be valid. And then I said, what I've seen is that rarely had counsel challenged it, and it's rarely excluded. And I then I don't know how much of this I want to read. The NAS reports of different calculus. In any event, I then ordered a hearing in every case and required the lawyers to come forward. It never happened in my court again. I ordered a hearing. The procedural order went all across the country. I don't know whether, no one ever, partly it's a function of the federal docket. In fact, I never had a trace evidence case again to address. But that was one institutionalized mechanism. The other is we train district court judges. We shouldn't be training district court judges. We should be training Court of Appeals judges. And the report that I referred to, the PCAST report, was really trying to say that there are certain fields that just should not be in court, and that this should not be admitted at all. I would suggest that if any of you have any trace evidence cases, ballistics, hair, whatever, you challenge it. Because there are challenges both with respect to the foundational validity and with respect to the as applied. One more note about the difficulty of the system of dealing with this science is reflected in the Massachusetts scandals. So there was, with respect to drug testing, you're not talking new science. It's very clear what the science is. It's not a big deal. There was a woman, one woman in one lab in the eastern part of the state who was so pressured to get the work done, the prosecutor would call up and say, you know, I need the results right away, that she began to phony up the results, phony up the quantity, phony up the drugs. Then there was a second scandal in the western part of the state where the tech was using the drugs. What does the court do? 40 years ago, I'm old, 40 years ago, you would say that when the integrity of the system has been undermined, these cases should be dismissed, period. In fact, what has happened is a much more tortured process about to what degree can the convictions be based on untainted evidence as opposed to the tainted evidence. 20,000 cases are affected by the Eastern Massachusetts case in various levels in the system, and they still have been unaddressed. So even when the science is unquestionably bad and the system has been distorted, we're still not dealing with it effectively.
Well, there's a list here of reasons that we've gotten into this mess, and the what I want to get to more quickly before we run out of time is what are we going to do about this? The question of how do we do it is, to me, it's the simple way of putting it is we need to follow the law. In federal cases, 702, which is the codification of Daubert, says what this should be subjected to, and it's not regularly being done. And we're talking about specific things judges can do and lawyers should argue for, but part of it is we don't have to have this all or nothing approach. It can be broken down. We also can do the mass way of doing it so that nobody knows exactly what is right or, I mean, which is the valid or invalid exhibit. The other thing is we've got to just say you cannot testify that you with certainty can make this determination if there's no scientific basis for making the determination. The whole question of getting them certified and the labs accredited and giving the jury limited instructions, and to end on a little humor, I think we need to answer that with no, this is not it. We're going to do better. It is going to take lawyers and judges being aware of this issue and taking appropriate action. You know, Texas has reached the point that they had so many exonerations and so many lawsuits, they set up a commission to just pay people that got exonerated. You just had to file an application and show you were wrongfully convicted and you spent this much time in prison and you got so many $1,000s per year. In fact, one of the first guys to go through that system ended up getting several $1,000,000 because he'd been in prison so long. He set up a foundation to start funding other inmates' requests to get out on wrongful convictions. So there are things happening that are positive, but as I said, there are things happening that are very negative, including like the execution of Mr. Willingham. And that case is so bad that the prosecutor who handled the case, after the Innocence Project got involved and said the science was bad, they said, well, it doesn't matter if the science is bad. We had an informant who testified he confessed in jail. This execution occurred in early, I think, 2002 or 3. This year, the guy who had testified he confessed got out of prison, called a press conference and said, I feel terrible because that guy didn't confess to me. The prosecutor had come to me and said if I would testify he confessed, they would cut my sentence in half and find somebody to support me while I was in prison. So I'm getting out way early because of that, and I got money each month from this so-called supporter, but none of it happened. So in the meantime, the prosecutor had been elected as a judge. So now the Texas Commission on Judicial Discipline is trying to get him removed from the bench based on his conduct in this wrongful execution. So that's enough from us. Anybody have any questions or comments? Yes.
Yeah, I practice patent law, so I haven't even thought about this stuff since law school, and it's been a while. So excuse me if everybody else knows the answer to this, but in terms of these exonerations, is there a but-for test? Is there a determination that but-for this evidence, there could not have possibly been a conviction?
You know, I am not an expert on exonerations. Do you guys know the...
Yes, the standard is that without the flawed evidence or with the newly discovered evidence, the conviction would not have happened.
So there is. So there could
Yes.
have been 10 pieces of evidence. Nevertheless, there's a determination that regardless of the other 9, there could not possibly be a conviction without that faulty evidence.
That's the DNA. I mean, that's what DNA has done to this field. You understand that before DNA, if a eyewitness withdrew their identification, a court didn't know which to trust, what they said first or what they said second. DNA suddenly cuts through that. So DNA exonerations are what all of these are about. And then you go back and you say, what else went, how did this happen? What was going wrong? But in other words, the DNA exoneration is able to know that we were just wrong, flat out wrong, to a great certainty. And then you can go back and say, how did it happen? And that's where those statistics about false identification, et cetera, there are very few cases reversed for false identification or even ineffective assistance of counsel, but there are many where there's a DNA finding.
Yeah, and the downside of that is that when there isn't DNA in this case, when you can prove that the science that convicted someone was deeply flawed, it's really difficult to get that conviction overturned because it's so much harder to meet that standard when you don't have clear evidence that they were actually innocent.
Now, one of the things that has happened that we didn't mention yet is the Innocence Project has this method of using DNA to get exonerations. The University of Michigan and Northwestern have a joint program where they take cases that don't have DNA. They're now up to over 1,300 exonerations without using DNA, just going back and reinvestigating the cases and looking at, I'm afraid in too many cases, it's inappropriate counsel behavior that gets the conviction. So the question that's totally unanswered that we can only guess is how many people are actually wrongfully convicted in our prison system, because the implication is a lot more than we've dealt with.
Can I have a quick follow-up to my earlier question? The term proven innocent was also used several times in the presentation. I mean, is that something that actually happened? It's one thing to say that they were convicted based on their hair being identified, with dog hair, and therefore the conviction should be overturned, it should be exonerated. It's another thing to say they didn't actually do the crime.
Yeah, the cases go both ways. I mean, I was on a panel in Iowa last year where they brought in a guy I'd never heard of from Kansas who was convicted in Riley County for a rape that he said he didn't commit. They had no eyewitness testimony because the rapist had put a blanket over the woman's head. They were relying solely on his confession that he gave after like 8 hours of interrogation. He goes to prison, serves about, I think, 8 or 10 years, finally gets released, and he then contacts the Innocence Project to try and get his record cleared up. They asked what went on with DNA analysis, and the county had not done any. They thought once they had the confession, they didn't want to spend the money on the DNA, but they had all the samples still. So they did the DNA analysis, and the trial judge's decision was the guy was determined to not guilty and therefore was totally exonerated. I know there are other cases where they just back up and say, well, it wasn't enough, but it doesn't determine innocence.
There is actually determination of innocence.
Yes, the statistic about the first 300 exonerations, those are DNA exonerations where someone else's DNA was on the victim at the crime scene. They're actual innocent cases.
Anything else? If not, thank you very much.